A legal fight taking off, a case raising serious questions about airline passenger rights, corporate responsibility, and how far airlines can go. What happened on one flight could change the rules for religious travelers nationwide. Welcome to Faith and Politics, a show dedicated to discussing issues surrounding the intersection of church, state, and politics, and the examination of whether you're allowing your faith to shape your politics or your politics starting to shape your faith. In other words, what do you do when God and government come face to face? I'm your host, Orlin Johnson. Let me introduce you to our guest panelists that we have with us today. First, we have Dr. Amilcar Gröschel, a pastor, an attorney, and a professor of philosophy, theology, and law at Washington Adventist University. We also have Dr. Andrew Polk, a professor of history at Middle Tennessee State University and the author of the critically acclaimed book, Faith and Freedom, Propaganda, Presidential Politics, and the Making of an American Religion. We also have Mr. Joseph Richards, who's the general counsel and director of public affairs and religious liberty for the Seventh-day Adventist Church in Canada. And we have with us Judith Hawkins, a former judge and attorney in Tallahassee, Florida. Great to have you here with us and looking forward to our conversation today. A retired UK pastor will stand trial facing criminal charges for preaching a gospel sermon inside a protected abortion buffer zone. Clive Johnston, 76 years old, faces 2 charges under the Northern Ireland's Abortion Services Safe Access Zones Act for conducting a religious service based on John 3:16 near Causeway Hospital. The Christian Institute Workers Protectors accused Johnston of influencing a protected person, whether directly or indirectly, by conducting a protest near the hospital where abortions are performed in violation of the law. He is also accused of failing to leave the safe access zone when directed. This law bans anti-abortion protests and other behaviors within a buffer spanning 100 to 250 meters from each entrance or exit of an abortion provider. You know, Andrew, we've been starting to see a lot of these cases that are happening not only in the United States, but the international aspect of these things seem to be spreading far and wide. You know, the idea used to be, well, if it's happening someplace else, it may never happen in America. But the reality is the world has gotten so flat. This what's happening in somebody else's backyard could be easily happening in my backyard and vice versa. This seems to be one of those type of cases. Somebody in a buffer zone, somebody preaching, and they actually even had his text from the sermon, John 3:16. But as a result of all of that, somehow he finds himself in court. He may find himself in jail. He may find himself having to pay fines. What's happening in our day and age now where we're trying to figure out how do we make sure we're protecting public spaces, but still allowing people to be who they are from a religious standpoint?
You know, I think the question itself nails the tension here, right? There's an aspect of this that is clearly trying to protect folks. I think that can be, despite my opinions on abortion, right? This can be an aspect of women in vulnerable positions going in, right? Being told. That doesn't seem to be what's happening here, right? So this is the Causeway Hospital. This is not what's called an abortion clinic, right? This is a general hospital. He is preaching outside of it. I wondered this at the beginning and couldn't find any real information of this. There's always the possibility that, though he's preaching on John 3:16, that in reality, this is exactly what he was trying to do, to catch women coming in and to give them a message. I do think that's an extenuating circumstance here. I think the difficulty of it is, again, this is a general hospital. With this aspect, it just seems like this is public preaching. This wasn't the intention. He's preaching not on abortion, on one of the most well-known verses in the New Testament, that this is one of those aspects where the protections make sense, but the enforcement of those protections seems to go so far that it's not bringing in the reality of the way humans live their life.
Well, I have the counterpoint position. I did
Imagine that.
serious research on this, and my serious research came off of Facebook, TikTok, and Instagram because that's where it all is. And they looked like there were about 22,000 emos, like 3.1 thousand comments, 3.4 shares, and I didn't have time to go through all of that. But let me point out just a couple comments that I noted that I think are relevant. These two, I think, are on point. Number one, if he'd been preaching about Muhammad, would he have gotten criminal charges? And the other one, I think, is the ringer. He could have preached the sermon outside the buffer zone and been within the law. Now, here's the other side. And this is what I think why he should probably be prosecuted. Proclaiming God's word brings guilt to the world. And if God is proclaimed as the sovereign, which his word declares the word in the world, then people are uncomfortable. The next one is this one. He may not mention, but their consciousness condemn them. And I love this one. Because even without preaching about sin, the guilt is there. And then here's the other little tidbit I found. Clyde had campaigned in the past on abortion. If there had been anti-abortion placards on display, if Clyde had made the side swipes at abortion, I could understand why the police would take an interest. But abortion was not mentioned, not once, not even tangentially. My question is, anytime you preach the gospel and you do John 3:16, somehow, some way, you're definitely making a comment about the sanctity of life. And therefore, I think there's influencing going on. Just move outside the safety zone and preach out your heart.
Oh, Orland, the challenge for me here is where should we draw the line, right? If the state defines the legal concept of influence too broadly, it risks restricting and shutting down even quiet, non-disruptive expression, freedom of speech in that case. And when that happens, the issue is not just about protecting space or buffer zones. It becomes about limiting what kinds of ideas can be presented in public. At the same time, religious expression should always carry its own responsibility. The strongest form of witness is never forceful or intrusive. It's never coercive. It's never based and should never be based on fear. And that's what Judge Hawkins was sharing. It should never be based on that kind of narrative. It draws near. The gospel should draw near and respect the context and the people that are involved. It respects their decisions as well as God does. So what this case really tests is if we can maintain a careful balance, protecting individuals' choices without pushing peaceful expressions or of beliefs out of the public altogether. And the balance is essential if freedom is going to remain something meaningful in our days.
You know, Joe, you are uniquely qualified outside of the United States and maybe in one of the more secular countries that exist. You know, so the idea of what may be deemed preaching in public may have one feel in the United States. Well, my guess is Canada, it may feel completely different and the laws may be governed in a different way.
Well, you're right, Orland, but, I look at this and I put on my prosecutor's hat. I used to be a prosecutor. And I think, even in Canada, this would be a step too far. If you kind of zoom out, one of the key questions that prosecutors ask themselves is the public interest. Is there a compelling public interest to go forward with this type of prosecution? Of all the types of conduct that are going on in society today, should we be going after and investigating, the 76-year-old pastor, or are there other things that can be dealt with, or more serious issues that need to be investigated? So that's kind of a broad issue that would be my first reaction to this type of case. The second is that, Canadian law really looks at the proportionality of the action, whether the action is narrowly tailored. If you're going to restrict speech, and we have constitutional protections here for free speech in our Charter of Rights and Freedoms, the courts really emphasize, okay, government, are you tailoring this as much as possible? Are you minimally impairing individual rights? Are your means, are they proportional to the risk that is there. And we all know the context, the historical context around protests involving places where abortions, in fact, are happening. But still, if you look at the video of the interaction between this pastor and the authorities, he was completely respectful. He was thanking the officers. This does not seem like a situation where that really calls for prosecution, and it sets a disturbing precedent potentially.
But what about, number one, he was within the zone. So if he just stepped out the zone, 1 foot over the zone line, we wouldn't be here. And number two, what about the very subtle but very real implications of what he's saying? As I agree with that, with one of the other panelists, he's trying to influence. I'm not so sure that this is as benign as we may want to make it. And I will agree that it would seem that prosecution of this case is not the best or highest use of the resources. But this is a very important principle, because there are people who don't want to hear John 3:16 and the implications thereof when they are going about their business. And the hospital does, in fact, perform abortions, and he does have a history of being anti-abortion.
I think this is what Dr. Gröschel said. I think balance is the key word here. Right. I would agree with you, Judge Hawkins, if this was what's called an abortion clinic. It's a misnomer, right? But where the principal medical procedure is an abortion, that makes sense, right? This is a general hospital, right? So because abortions can be or are performed there, if I'm going in to get my leg checked, if I'm having it's just a major general hospital. And the idea that the zone must come from anywhere is, no matter what you're talking about, it's religious and someone could perceive it to, that seems out of balance, right? I'm not actually opposed to these safe zones. I think that makes sense in everything that you're saying, Judge Hawkins. This seems like an application that's so broad that it's not serving the actual intent of that safe zone. And that's where it becomes problematic to me.
Well, and I think that's the real question here. How do you create an environment where you're hoping to, quote unquote, have some safety that's taking place? The idea of just stay outside the buffer zone and you don't have anything to worry about. But I think that's also another point of interest. There was a very simple way to not have any problem at all. But some of us believe, but you know what? If I'm doing what I believe is good or in the will of God, why should anybody tell me where I should be? And that's another part of what we've got to worry about. And, and Joe, that's where I think it gets a little tricky.
Circumstances do matter, right? And so I really would be interested to see exactly where was this happening vis-a-vis the actual roadway, vis-a-vis the actual entrance to the hospital. All of these facts, as they say, facts matter.
Right.
Sometimes bad facts make bad law. I remember that from law school, right? So really, you need to get into the nitty-gritty of the facts here.
I'm going to have to let that be the last word, but, I think we kind of have zeroed in on the idea that we want to make sure that we've got some rules and regulations in place, but we don't want to overstep because we feel we are entitled to, in particular because of our religious beliefs. And I think that's the crux of the matter. We want to make sure we don't cross that lane. Coming up, an airline company taken to court for firing employees who had religious objections to getting the COVID-19 shot. Stick around and we'll be right back. When faith and government collide, the issues can be complex and consequential. Faith and Politics explores how religious conviction intersects with law, policy, and public life, offering depth, balance, and clarity with meaningful discussion and trusted insight. To see a bunch of our previous episodes, check us out at faithandpolitics.tv and subscribe to us on YouTube. There's a case that's called Hampton versus United Airlines, in which United Airlines has been sued in 3 lawsuits on behalf of former employees whose religious rights were violated when the company unlawfully refused to take part in the Title VII of the Civil Rights Act of 1964 religious accommodation process and fired them over its COVID-19 shot mandate. They each had religious objections to use of the aborted fetal cell lines associated with COVID shots and chose not to inject themselves. The first lawsuit was on behalf of a pilot, He was a first officer who was a United pilot for over 25 years. The second lawsuit was over a former 26-year contact center reservationist, Supervisor Christina DeBusk, who only worked remotely and never had any contact with fellow employees. DeBusk was also adversely denied retirement and fired over her religious beliefs. The third lawsuit is on behalf of a former flight attendant, Gentana Hampton. For 28 years, Hampton served as a dedicated flight attendant, working through holidays, missed family milestones, and even sacrificed vacations so coworkers could be with their families. You know, Joe, when I take a look at these type of cases, on one hand, we want to make sure that we're focusing on the public safety aspect of things. COVID obviously was a pandemic. It was something we were learning. But in the same breath, there should be probably some balance in how we go about this. There were clear exemptions if you had some religious issues. But then we even see situations where you got people who are even working remotely that had no contact with individuals, and somehow the courts seem to sometimes get these things wrong. What are we missing here? And is there something that we should be focusing on, or maybe the court should be focusing on, or even individuals who are seeking exemptions, is there something they should be focused on? What are your thoughts on that, Joe?
Well, a couple of points. Sometimes what happens is what you call overreach, and you just go too far. Maybe the intent is good. You have a public health crisis that was going on at the time, and you want to protect public health, but sometimes you go just too far. So the question really that we need to think about is process. When you're looking for an exemption, what type of conversations are going on between the employer and the employee? Canadian law is very focused on the process. Employers have a duty under our human rights legislation that applies coast to coast to coast. The question is really, did the employer, did they in fact engage in that serious and meaningful conversation with the employee? And if not, even if you look at the requirement is not maybe even that onerous or burdensome, the fact that that conversation, that earnest one-on-one didn't actually happen, courts will actually rule against the employer. There's a famous case from our Supreme Court of Canada in 2006 involving a student who was carrying a kirpan. And for those who don't know, a kirpan is like it's like a religious knife that Sikhs wear underneath their clothing. And, you could think about this as a teenager in a school with a knife. Of course, the school board has an interest in preventing that from being there. But the Supreme Court ruled in favor of the student. Why? Because the school board didn't even engage in a conversation, didn't even look for alternatives. And that can be, in fact, fatal to the argument of an employer, of a school board, of anyone who is seeking to suppress the rights of others. So those are some things to really keep in mind when analyzing this type of situation.
Man, I love it, Orland. Process. In our North American context here, how seriously should an employer take its obligations under Title VII?
Yeah.
How seriously should they take it? That the law doesn't prohibit religious discrimination in theory. It actually requires employers to actively work out alternatives with the employees when a sincere religious conflict happens. And in this case, that's exactly where the tension lies. You have several long-term employees of many years who raise those concerns, not about vaccines in general, is what it seems, but about that specific one that uses fetal cell lines in the production. So if you're taking Title VII and its requirements seriously, that complaint should have triggered what's called an interactive accommodation process. The employer and the employees would need to sit down and try to find reasonable solutions for both parties, and this is important, not with a guaranteed outcome, but there must be genuine effort of engaging in that accommodation. But based on what we can see in these lawsuits, that step was either rushed or simply skipped.
Judge Hawkins, I don't know, Amilcar sounds like the son of a judge, right? But I imagine that judges hate the idea of having people who came to them prior to trying to work it out on their own. And that seems to be exactly what we're dealing with here, a set of circumstances where no conversation, don't try to work this out. Let's just get to court as quickly as we can and find some third party who hopefully will say something that I'm hoping for. I mean, is that what we're feeling a little bit here in this case, Judge?
Well, I see something totally different. I do remember doing some research on it. However, the text that we have says that they didn't even bother to follow their own policies, which for me is a very important factor right there, that United did not follow its own policies, that there was a court injunction against their deadline, and that they simply refused to reconsider. So before I get to all of these deep issues that you all have, I'll stick with the first one, which is United had policies that would have addressed these issues. They did not follow them. That sounds to me like I could make a call on that ball and leave it right there at that point, and the rest of it would be wonderful dicta. Simply say, y'all didn't follow your own policies, and that's a slam dunk for the plaintiffs.
Andy, what do you think about that? We're not even following our own policies, but is there a bigger issue they're trying to deal with here? It sounds like United is trying to be in multiple places and be on multiple sides of arguments. I want to be, quote unquote, supportive of making sure we're getting shots. I also want to make sure that employees are basically doing maybe what we tell them to do and not even taking into account who these employees are. I mean, you have somebody who worked there for 28 years who are sacrificing things on behalf of the company, but none of that seemed to come into play here. Am I missing something here? Or is this really, maybe an airline that's just gone too far?
Yeah, I don't think you're missing anything. This seems to be one of those questions of reasonableness. And we've gotten these a lot related to the COVID pandemic. I think understandably, right? It's a massive health crisis. People aren't sure exactly what the best policy is. And the tendency was, well, you make a big policy and you stick everyone to it, because if not, there's going to be so many exceptions, right? The Judge Hawkins' slippery slope, right? If we have one exception, then everyone's going to have exceptions, and then no one's going to follow it. And to be honest, we've seen some not necessarily goodwill on either sides of this issue with COVID and the vaccines. This one seems pretty clear cut in that they created an arbitrary deadline that they didn't themselves follow consistently. And the reasonableness factor for these is just off the charts, right? I'm not coming in and going to be around anyone. Well, but it's our policy and everyone has to regardless. Well, I was on medical leave, and then, right, it's not that it slipped my mind for one of these folks that they just forgot to do it, file it in the time. No, they had a very objectively reasonable reason why they didn't do that. The inability of this company to just take some type of reasonable standards in account here seems to be the biggest issue. And I get the tendency. This is a rule and everyone's going to follow the rule. And that seems like a form of fairness or justice. It's just, it's not the way it actually works in the rule.
Well, I got two comments. Number one, common sense appears not to be so common these days. And number two, Adam, everybody's going to follow the rule. Well, you should follow it yourself, because not only will this court would have ruled against you, but it would have sure have helped the damages claim for the plaintiffs. If I was on my lawyer hat, I would simply represent them on that one point right there. You didn't follow your own rules, period.
Well, there's one aspect here that, just to reply to the judge here, it's that four-letter word, fear. Fear causes a lot of things to happen. And we have seen, you mentioned earlier, during the pandemic, a lot of things happen out of fear. So I'm just wondering, this really this is a cautionary tale, right, of what can happen under very stressing and distressing circumstances, and where policies, one could argue they were not created for that time that we all endured. So it's very difficult. And I know this judge is very definite on that, but I know a lot of other judges would say, hold on a second, look at the circumstances. Maybe I'll listen a little bit longer to what the employer is saying here.
And Joe,
So
at the
tell
end
me
of the
what the
day,
employer is going to say when I work remotely, I have no contact with anyone. And by the way, should I get COVID? Oh, there it is. I got COVID, and that created an economic hardship for the employer because they had to find somebody to replace me. Oh, okay. Okay.
I agree with you. I don't know if everyone would.
And at the end of the day, this case is really asking something very practical. When conviction and policy come into conflict, and it will sometimes, are we willing to slow down long enough to deal with people as people? Because that's where both good law and good judgment tend to meet, where people treat each other as people.
And I'm gonna have to
Maybe
let
that also goes into the policy. The process of making the policy should have some common sense or provisions in it for people to be people.
And actually, I'm going to let that be the last word. And that's probably what I was going to say anyway, Judge. So I feel okay with that. But I think the big picture of all of this is the common sense aspect of life is still important. But I think what we're learning is what we used to call common sense is not that common. And that's why we're going to see more and more of these type of activities. Hey, Judge Hawkins, tell me something I don't know.
Do you know that octopus have 3 hearts, 2 just to pump the blood through their gills and 1 more to circulate it through the organs? And that's why octopus like to crawl, because if they're trying to swim, it stops the heart from beating.
I'm glad I don't eat that. All right, Andrew, tell me something I don't know.
Well, we talked about COVID and vaccines today. Did you know that the strangest plague that has hit Europe was in 1518 that we call the dancing plague? There was a woman named Frau Trophée that just started dancing one day, and then her daughter did, and then hundreds of people did, to the point where their feet bled. Multiple people had over 24 had heart attacks and died. And then within 2 months, it just stopped. And there's still no vaccine developed today.
That's why I don't dance. Amilcar, tell me something I don't know.
Well, talking about Europe, Orland, did you know that Oxford University is older than the Aztec Empire? Teaching began at Oxford around 1096, but the Aztec didn't become a civilization until the 1300s. So students were already attending lectures in England centuries before the Aztecs built their capital.
Wow, didn't know that one. Joe, tell me something I don't know.
Well, I am Canadian, and we're in the true north, strong and free. Did you know that Canada still has an established church? You have to understand that we don't have a president. We don't have a prime minister. Our head of state is the King of Canada, who is, in fact, the King of England. And under the Act of Settlement, 1701, has to be in communion with the Church of England. So we have a very interesting system. Although we're secular in some ways, on the books, we're a little less so.
Didn't know that as well. Listen, really appreciate the conversation today. Always learning something new. And thank you again for being here with us. Hope you enjoyed our conversation. Just remember, if it's about God and government, it's faith and politics. See you next time.